Well, in an important development today, the Bar Council of India informed the Chief Justice of India, S.A. Bobde-led bench, that its rules notified in early January 2021 regarding scrapping of the one-year LLM course across Indian universities will not be made applicable from this academic session, and that it would come into effect from 2022 to 2023. The statement was made after a consortium of national law universities, along with certain individual LLM aspirants, had moved the Supreme Court challenging the impugned Bar Council of India rules, which scrapped the one-year LLM course. To this, Chief Justice of India, S.A. Bobde, noted that interim relief in this case would not be needed after the statement made by Senior Advocate Manan Kumar Mishra, who is the chairperson of Bar Council of India. Senior Advocate Mishra also informed the court that in the month of March 2021, there is supposed to be a high-level official meeting which would have former judges and senior lawyers, including Dr. Abhishek Manu Singhvi, who represented the consortium for the national law universities, and that this issue may be settled there in the meeting itself. To this, the Supreme Court expressed a hope that there may not be a need for a judgment from the top court regarding this. Nevertheless, a notice has been issued to the respondents in this case. Bench led by Justices D.Y. Chandrachud, Indira Banerjee and Sanjeev Khanna today ruled that any person suffering from a neurological condition or writer's cramp is entitled to the facility of a scribe, or a person who writes the exam for you for the civil services examination. The Supreme Court of India today also directed the Ministry of Social Justice and Empowerment to frame guidelines so that persons suffering from this neurological condition of writer's cramp be allotted scribes for their examinations, as they are covered under Section 2S of the Disability Act. The Supreme Court has asked the ministry to frame these guidelines within 3 months of today's Supreme Court order, and that in the decision-making process or while formulating these guidelines, the disabled, or especially the disabled rights activists and organizations, are also taken into account. The enactment of the 2016 Disability Act legislation is a watershed moment to provide equal rights to the disabled. Handicaps encountered barriers of prejudice and discrimination. These barriers have origin in social and economic inequalities. Justice Chandrachud further said, "This act is a statutory enforcement to the right of equality enshrined in the Constitution for the disabled. For a person to live a life with dignity, we must ensure that we provide them equal support necessary." The interstate Kotia border dispute between the Odisha and Andhra Pradesh today again reached Supreme Court after Odisha government filed a contempt petition against the state of Andhra Pradesh for violating their 50-year-old status quo regarding the Kotia Panchayat, which consists of 28 villages. The contempt plea comes in the backdrop of the recently announced Andhra Pradesh Panchayat polls, which slates to hold polls in especially 3 contested villages of the Kotia Panchayat from February 13 to February 17, on which both Odisha and Andhra Pradesh assert equal rights. A Chief Justice of India, S.A. Bobde-led bench will be hearing the case tomorrow. Lastly, the Facebook India head Ajit Mohan versus the Delhi's Peace and Harmony Committee case progressed before a Justice Sanjay Kishan Kaul-led bench of the Supreme Court. Senior Advocate Rajiv Dhawan, today wrapping up his submissions, argued that the Delhi Assembly was a completely constitutional assembly formed under the constituent powers. He further argued that the Delhi Assembly was not inferior to any other state assemblies of the country. India is a democratic country today because of Pandit Jawaharlal Nehru. There was a rule then that members of the parliament do not speak about it in public. Coming to Facebook, fact that it is a non-member of the House makes no difference to invocation of breach of privilege. Dhawan further argued, "You just cannot allege malafide against the person by showing a press conference. If you want to make a case of malafide, then make it. What you see here is surreptitious malafide. Footnote to a summon here is being called a malafide." Well, that's all from Supreme Court today. Do stay tuned with Supreme Court today, tomorrow as well. And don't forget to like and share barandbench.com.